Hi, friends. Today, we're going to talk a little bit about the organization of the federal court system. And I thought we would start first by looking at a map that shows us the difference between the federal court system at the time of the Judiciary Act of 1789 to September 24th, 2019. Which seems a long time ago. But after all, I think the month of April had about 57 days in it. So we're going to take a look at how it is that these different components of the federal court system work and operate. And hopefully you're going to better understand how our United States legal system is set up. So let's talk a little bit about this system. Our federal court system is three-tiered, as you can see. And I tried to highlight this in the last video, but I really wanted to focus heavily on it in this video, so I kind of went through it quickly in the last one. So as you can see, there are these trial courts, and they are the bottom level of this system. There's a court of international trade and a court of claims. We don't worry so much about those because they don't have as many cases as, say, this last one does, this U.S. District Court. As I mentioned previously, I'm also going to show you another slide about this, but the U.S. District Court has 94 courts, and every state has at minimum one court in it. In addition, there is the appellate court system, or what we call the circuit courts. And there are 13 of these circuit courts. And at the top of the system is the United States Supreme Court. So we're going to take a look at some of these and try to better understand how it is that they operate. I think for our intents and purposes, I want to jump right in and talk a little bit about the United States Supreme Court. It's the one that you have a little more familiarity with. As previously mentioned, there are 9 justices of the U.S. Supreme Court. And there have been 9 justices of the United States Supreme Court since 1869. That number is fixed by law. As mentioned earlier too, there was an attempt in the 1930s to increase that number, but it was a purely political reason for doing so under Franklin Roosevelt's court reorganization plan. Sometimes that's nicknamed court packing. All of our justices sit en banc, and that's ENBANC, en banc. And what that means is they all sit together. All 9 justices hear the case. It's not like you have 9 in the pool and only 2 of those justices hear the case. Sitting en banc means everybody who is a judge or a justice hears the case at once. So there are 9 and all justices sit en banc. These U.S. Supreme Court justices serve for life. To be fair, like in good behavior, the Constitution does talk about that. But you can serve as long as you're alive, as long as you want to serve. Some of our justices or previous justices, like Associate Justice Sandra Day O'Connor, chose to retire relatively early, and then she developed the iCivics program, a program that we've looked at a couple times. I definitely use iCivics a lot more with my general government civics class of seniors. But that's what she's done in her retirement. Others choose to serve until they die. As a result, you end up with, generally speaking, a relatively older population sitting on the U.S. Supreme Court. In fact, I just saw a graphic about this today, that there are many, many Supreme Court justices that are over the average life expectancy for an American citizen. And, Justice Ruth Bader Ginsburg is a great example of that. I think she's 86 now. I was listening to her yesterday in oral arguments. She's still asking very poignant, very deliberate questions. She's responding to questions or responding to arguments rather quickly. So all indicators, at least from our perspective, that she's sharp and still with her on her A game are there. She gets to serve as long as she wants to serve. She can choose to step down if she wants to, or she can choose to die in office. That's her, or die in the position, and that's her choice to make. So Justices get to serve for life. This is a collegial court, meaning they're friendly. They're not adversary. They're not enemies of each other. They get along with each other. One of my favorite routines that Chief Justice John Roberts has implemented is that he meets with the team of justices, the 8 other justices, behind the curtain before oral arguments and before decisions, and they have a quick powwow meeting, chit chat, and then turn around and walk out. And so they have this sort of positive, friendly environment that they work within. They have original jurisdiction for very few cases. Original jurisdiction means the case goes to them first. Instead of a case going to the trial courts and then to the appellate court and then to the Supreme Court, original jurisdiction means the case starts here. An example of an original jurisdiction case we've talked about was Marbury v. Madison. It directly went to the U.S. Supreme Court. And that was part of Marshall's decision in Marbury v. Madison was that, the U.S. Supreme Court doesn't have jurisdiction in this issue. It really should go somewhere else. The United States gets jurisdiction in very limited or original jurisdiction in very limited cases, and Article 3 of the U.S. Constitution sets those cases out very clearly, by all means. Otherwise, they get appellate jurisdiction. Again, case goes from one level of court to the next, and then to the next. So that's appellate jurisdiction. The United States Supreme Court typically gets about 10,000 cases a year. They used to decide around 80 or pick up about 80 cases. Now they're sitting around the 60s, 67, 62. I have to look at the most recent numbers. But some of that has to do with just the nature of the cases that they're hearing. Things are moving a little bit slower in the court. I imagine they're definitely moving a little bit slower in the court right now. But ultimately, they get over 10,000 cases on appeal from either state Supreme Courts or from the U.S. Circuit Court of Appeals. And what's really interesting is that they have total discretion over their docket, meaning the U.S. Supreme Court gets to pick and choose what cases it wants to hear. It is a misnomer or misbelief that the U.S. Supreme Court has to take every case. They don't. They get to pick and choose. So the cases that they're choosing to listen to arguments on are the cases that are of high interest to them. It means that there's something in the law that they feel like they need to settle. Otherwise, they wouldn't take it. They would look at it and go, well, it looks like the Court of Appeals made the right decision. We're cool, and we'll leave it at that. So if the Supreme Court takes a decision, it's more likely that they're going to overturn the U.S. Court of Appeals decision, right? Otherwise, they would just let that decision stand, or what's called stare decisis, let the decision stand. But if the U.S. Supreme Court is going to take your case, then it's likely the reversal rate of the Court of Appeals is going to be around 60 to 65%. More than likely, if the U.S. Supreme Court is going to take your case, it means they're going to reverse the decision that was made by the Court of Appeals. They primarily deal with claims on constitutional issues. So that's why when we were studying civil liberties and civil rights, we were looking at cases that went to the Supreme Court. Those are primarily the types of cases that they take. The next level of court is the U.S. Court of Appeals, also called the circuit courts, and those are regional. I'm pretty sure my next slide. Here we go. It talks about these courts. So you can see we live in the Ninth Circuit. That's everything in purple. So they are regional courts. There are 12 circuit courts and a U.S. Court of Appeals. There's the D.C. Federal Court and the D.C. Supreme Court here. But we'll look at ours, for example, and you'll notice that the 9th District is a really big district, which includes Alaska and Hawaii. By all means, it is one of the most active districts that we live in. And if you want to argue a case or send your case up to the 9th Circuit, you would have to go to San Francisco because that is where the circuit headquarters is. In the circuit, in each of these circuits are combined total, there's 179 federal judges. Those judges have appellate jurisdiction, meaning they take cases from the district level. They never have original jurisdiction. A case never comes to them for the first time. It comes to them from the U.S. District Court. And ultimately what judges are looking for at the Court of Appeals or the circuit courts is that they're looking for mistakes that happened at the district court level. That's their job. They do hear criminal and civil cases. I'm going to talk about the difference of that in a minute. And they get about 60,000 cases that come to them a year. The reversal rate is about 20%. So it's not likely that if you send a case from the district level, go back to my previous slide. If you send a case here, you don't like the decision. If you send it to the appellate court, it's not a high likelihood, one, that case is going to be picked up, or two, that the judges on the Court of Appeals are going to reverse the decision. It's just not likely. The judges sit on panels of 3. So 3 justices or 3 judges, we call them judges at the circuit court level. 3 judges hear the case. They decide together. So it's not quite the 9. It's not all of the judges that are in that circuit court because there's more than 3 judges. If there's only 13 total, 12 circuits, and then 1 U.S. Court of Appeals, that's 13 courts general, 179 judges. Amongst all those, there's certainly more than 3 per circuit, but only 3 listen to each case. Lastly, we'll go back real quick. There are your district courts. As we've chatted a few times now, we know that every state has at least 1 district court for a total of 94. Washington State, as you can see, notice my ode to the Seahawks. We have 2. We have 1 in Seattle, and then there's a secondary split off in Tacoma, and then there's 1 in Spokane. So if a federal law, if you want to challenge a federal law, or you're in trouble for violating a federal law, and you're on this side of the mountains, you would present your case or have your case argued in the Seattle district court. I had the opportunity to go listen to a case being decided in the penalty phase, I should say, like what the punishment was going to be at the U.S. District Court in Seattle. It was a case of an individual who had violated the Clean Water Act by dumping the bilge in his boat, his fishing vessel, into the Puget Sound, which is gross. And so the Environmental Protection Agency had sent lawyers to prosecute the owner of the boat for violation of the Clean Water Act. So that's a federal law, right? The Clean Water Act. This person got in trouble for violating it. So instead of going to like a local state court or hauling them into Cowlitz County or something like that, instead you go to the U.S. District Court because you violated federal law. The same would happen, of course, if you violated on this side, the eastern side of the mountains. You'd end up in Spokane and have your trial there. There's just 1 judge who would preside over the trial. There's multiple judges who serve in the district court. They're all federally appointed judges, meaning the president appoints them. They're confirmed by the Senate. There's roughly about 650 of these judges throughout the United States. And every district has at least 2 judges. The Seattle district has a lot more. And then there's some that are kind of working part-time to fill some of the needs because there's definitely a lot of cases in front of the U.S. District Court right now. They serve for life, and these are trial courts. So in my example I just gave you, right, this man was put on trial because he violated a federal law. He has an attorney. The United States has an attorney that's prosecuting him for violating a criminal act. So I'm going to talk about that here in just a moment. Hopefully that's clear. If you have questions, please write them down. I really want to hear them. I want to also talk a little bit about the participants in the legal system. There is a difference between a criminal case and a civil case. So criminal cases are where the government charges an individual for violating a specific law. There's a law that's been violated, right? Think about this as my example of the Clean Water Act, Clean Air Act. Somebody is polluting. That's a federal law. You're breaking that law. And then in the case of civil law, we're talking about there's not a charge of criminality, but there's a payment for wrongdoing. So you could be brought up on a civil case for Well, we'll look at Barron v. Baltimore, right, which is where this person was seeking financial compensation because they saw that part of their peer was being taken, and they wanted compensation under the Fifth Amendment, right? That's a civil case. It's not a criminal case. There's money that's given for wrongdoing. So these are some of our participants, but there's also other participants in the legal system too that we need to talk about. We've talked about justices already, so we know who those are, and judges are basically the judges who aren't serving in the Supreme Court. We call them justices of the Supreme Court. Everybody else is a judge. I want to talk with you briefly about the clerks so that you understand what clerks are. Every judge and justice has at least one clerk. Members of the United States Supreme Court have more than one clerk. The clerks basically do the dirty work. That's meaning that they write, they sift through the 10,000 cases at the U.S. Supreme Court, and they decide which cases a justice actually should consider looking at. So think of them as like the filter for the justices. All federal judges do have clerks, though, and that clerk assists them. I have a friend who is a clerk for a district judge, and basically, his job is to sift through, to answer phone calls, to problem solve for the judge, to get the judge the documentation he needs to find, look at previous law. He'll grab the case law for that judge. He'll read and be an editor for the judge. It's a pretty big job. In the United States Supreme Court, the justices pick their clerks. It's an awesome job, I think, but I think it would be exhausting after a period of time. Basically, they are students who are in their last year of law school or just coming out of law school who will serve for 1 year terms, and maybe sometimes more, just depends. The pay is, around $70,000 to $80,000 a year. And if you clerk for the Chief Justice, you receive a little bit more. And if you're curious if do the justices pick clerks that are aligned with them politically? This was a question. I got to have lunch with a clerk last time I was in Washington, D.C. And actually two clerks, one who was a clerk for Ruth Bader Ginsburg and the other who was a clerk for Justice Thomas. And what I found really interesting is that in both cases, and I'll add, maybe you don't know, Justice Thomas was appointed under Republican presidency. Associate Justice Ruth Bader Ginsburg was appointed under Democratic presidency. One might think of Justice Thomas as being more conservative. One might think of Justice Ruth Bader Ginsburg as being more liberal. With that said, I blatantly asked at the lunch, do the justices seek out or ask you questions about your own political allegiance or where you stand liberally and conservatively? And in both cases, the clerk said no, that would be completely inappropriate. What they're looking for are clerks who see the law the way they see the law. Whether you're a constitutionalist, whether you believe in the living, breathing document of the Constitution or something that lives much like Justice Scalia would tell us, we want to think about what the framers thought about this concept, not how we apply it in the modern era. In some cases, the justices are just really looking for hardworking folks. And so it's really interesting to me that they can divorce conservative and liberal. Chief Justice John Roberts once said that the Supreme Court is not a court of liberal justices or conservative justices. It's a court of justices that deal with the law and see the law. They're not liberals or conservatives at all, and that's not how they view themselves. So it's very interesting. It's not necessarily what we might think, but those clerks are really, really important. There's also major players of these attorneys. There are attorneys who argue cases, of course, in the United States Supreme Court. The Supreme Court has a bar, meaning I don't mean a bar where one might, a saloon. I mean, they have a test to be able to be admitted into the Supreme Court to argue cases there. So there is actually a special room within the U.S. Supreme Court where attorneys can just sit and listen to cases. They can kind of check in. They go have lunch in the cafeteria and then go hang out in the room and just can be there. They can listen to cases whenever they want to. They don't need the special pass like you or I might need. So I also kind of quickly want to talk a little bit about some of these roles. I know that the screencast is getting long and I apologize, but there's a lot of information we have to go through. So I want to talk about a case and when you see petitioner versus respondent, who these folks are and what this all means. In the case of petitioner versus respondent, I'm going to back up. Actually, I'm going to go to plaintiff versus defendant first, because this was what you would see at district court. So at the district court, when you bring a case to the district court, saying that there's been a wrong, the person who is complaining is the plaintiff. So in the case of Condit versus Two Chains, Condit is the plaintiff, Two Chains is the defendant. So whenever you see it in that format, that tells you who is complaining and who is defending. So Condit versus Two Chains. Condit's the plaintiff, Two Chains is the defendant. Now, let's say that in my case of Condit versus Two Chains, Two Chains doesn't like the decision that was made at the U.S. District Court. Then Two Chains can go ahead and appeal to the circuit court, right? That's this level. In that case, Two Chains would be the appellant, person filing the case, and I would be the appellee, right? Two Chains versus Condit. So in this case, Two Chains is one of the 20% of people whose case is going to be picked up by the circuit court and potentially reversed. Now, if I don't like the decision, let's say the circuit court ruled against me, then I can take my case to the United States Supreme Court if they choose to pick it up. If I'm one of the 67, roughly, cases that are picked up by the U.S. Supreme Court, then we're called the petitioner versus respondent. And in this case, I would be the petitioner. I'm petitioning or asking the United States Supreme Court to hear my case, or what we call grant cert. It's called the writ of certiorari, to grant cert, meaning I want them to hear my case. So I would be the petitioner and Two Chains would be the respondent. Does that make sense that I am the complainer at first, Two Chains is the defendant? If Two Chains doesn't like the decision that was made, then Two Chains becomes the appellant. I become the appellee. And then if I don't like the decision that was made by the circuit court, I can take it to the U.S. Supreme Court, and then I become the petitioner, and Two Chains becomes the respondent. Okay? The person complaining ultimately is always listed first. The person who is, or party that is receiving the complaint or the complaint is about is listed second. The U.S. Attorney General is a major player in the system as well. There are attorney generals who operate in each state, and they're elected officials, but the United States has an attorney general who oversees the law. And within the branch of the Justice Department, where the attorney general is the head of, is a person called the Solicitor General. So who is the Solicitor General? Our current Solicitor General is Noel Francisco, who was appointed in September 2017. Solicitor General Francisco is working with a lot of other assistant solicitors. In fact, yesterday I was looking at this case with booking.com. It was the first case to ever be argued live and broadcast, which was awesome. It was a really interesting case, I thought. Some people thought it was really boring. But with that said, it was an assistant solicitor who was actually arguing the case. And what their job is to represent the United States' interests. So whenever you see a case like Nixon versus U.S., or U.S. versus blah, 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 U.S. versus Nickelback. In U.S. versus Nickelback, the Solicitor General or an assistant solicitor will be the one who actually argues the case on behalf of the United States. So we have talked about a lot. We have gone through who some of the major players are in the federal court system. We've talked about who the participants are, much less the difference between criminal and civil law. I've talked with you about the organization of the system with district courts, courts of appeal, and then information on the United States Supreme Court. So I know it's a lot. This was a pretty lengthy screencast, and I apologize for that, but we had a lot of material to get through today. As you're going to look at, your job over the next 2 to 3 weeks is just to watch one of these oral arguments. You can see them or listen to them, I should say, on C-SPAN. If you have TV, C-SPAN should be an included channel that you have. I have DirecTV, mine is channel 350. You can also go to cspan.org and hear the oral arguments. If you're struggling with finding them, let me know, and I'm happy to point you in the right direction. They'll take roughly an hour, so you need to plan for about an hour of time. Each side gets roughly 30 minutes. When they're live, they are broadcasting really early because the court is in session at 10 a.m. in Washington, D.C., which means it's 7 a.m. our time. What you may want to do if you have a recording device is you may want to DVR it so that you can come back to it, unless you're like me and you want to be up at 7 a.m. There is a really cool case that is coming up next week I'm super interested in. It's a case that comes out of Washington State. It'll be heard in front and argued in front of the U.S. Supreme Court on Wednesday of next week. And so I would really encourage you, if you're looking for a case and you're like, I want to listen to one, but I don't know which one to listen to, I would highly encourage Wednesday of next week to be the case that you look at or listen to. It's about the Electoral College in Washington State and what happens if somebody is selected as an elector who then decides that they don't like who won the race, and they don't want to have to cast their electoral vote for the candidate that won. That's called a faithless elector. So it's a faithless elector case, and I'm happy to do some previewing on that. I'd love to talk with you about it in a Google Meet. So as questions emerge from today's lecture, please don't hesitate to reach out to me. This is like my jam. I love talking about this stuff. So hopefully you are as interested as I am. And if you're not, I'm sorry. I hope to see you guys soon on a Google Meet.